Hi, everyone. I'm back, and we'll get started in just a minute here. So today, we're focused on preparing for the civil procedure sections of the bar exam. Preparing for the civil procedure MBE, that is the multiple choice part of the bar exam, comes with a big challenge because we don't have many real MBE questions to practice from. So today we're going to talk about why, but then more importantly, I'll show you an alternate way of studying that is still based on real questions written by the same people who write the MBE. And all of the past questions, these are essay questions written by Ncbi on the civil procedure topics. They're all available for BarMax UBE students. But if you are a student in the BarMax California course or in the BarMax MBE course that you're taking because your state has its own, unique and special essays, then you can email us or get in touch with support through the app, and we'll go ahead and send you a packet of all the ME civil procedure essays from 2009 to 2019. That's 18 essays, so those should be really helpful to you. And I'm going to talk about why they're helpful as study tools, even if you don't have an exam with the same essay format. If you have a 1 hour exam or a 1 hour essays or 45-minute essays, the ME essays won't look like your exam, but the fact patterns are really good study materials, and the Ncbi explanations are really helpful. We're going to look through one today, and then and I'll show you how you should use those as you prepare for the civil procedure portions of your bar exam. So why are there so few civil procedure questions, real MBE multiple choice civil procedure questions? That one is easy. We're still having problems. Muted, and I unmuted myself. Is it working now? Oh my goodness, I'm hearing that we're having problems with sound. I don't know if that resolved the issue or not. I'm hearing from several people that the sound is fine, and one person suggested that people call in to the webinar. Sometimes if your Zoom isn't working through Zoom, you can use your telephone app, your phone call app itself, and just call the number. But if you do that, you'll be able to hear on your phone and see on your computer. So you could try that. Wait, I'm saying all this for the people who can't hear. That's not helpful. Maybe one of our BarMax reps can type that into the chat comments and give people help that way. Anyway, I'm hoping enough of you can hear that this is helpful. And if your audio is in and out, we do have the replay. Okay, so I was going to say, why are there so few MBE questions on civil procedure? Well, this one is easy to answer. First, civil procedure has been on the MBE only since 2015. The multi-state bar exam, the multiple choice portion of the bar exam, has been around since at least the 1970s. But the civil procedure portion was added in 2015. So there weren't many to draw from. And number two, the National Conference of Bar Examiners, Ncbi, are the ones who write the nationally available parts of the bar exam, including the MBE. NCBE is notoriously stingy about releasing old questions. They don't release many questions at all, probably because they vet them year after year and rerun very slight variations of the same question. And so they don't want to tip their hand as to what might be on your exam. If you compare this to the LSAT, gosh, remember the LSAT? That felt like a lifetime ago, didn't it? Every year, the makers of that exam LSAC releases a handful of former exams. They've released, 80 something at this point. Imagine if we had 80 old bar exams to work with. We don't, okay? With the bar exam, all we have are about 1,600 released questions, a little more than 1,600 that are still considered current law. All of those are in the BarMax app, either in the sets of practice questions or in those online practice exams, the OPE. But of those 1,600 plus questions, only 46 questions are civil procedure. It's kind of pathetic, isn't it? The online practice exams were taken from exams prior to 2015. So they don't include civil procedure. So when you take the online practice tests, and if you're taking a July bar exam, you may have taken one this week, because our schedule recommends taking OPE 1 in the first week of June. You'll find that there are no civil procedure questions. You'll get to see how you're doing, and you'll get 100 practice questions that you can now work from in all of the other subjects: constitutional law, criminal contracts, torts, and so on, but you will get nothing for civil procedure. So moving on to the more important question for today: how can I prepare? How do we overcome the lack of MBE questions? 3 things, the third being the one that will apply to all of you. But the first 2 for BarMax students is, look, we're happy to have, Professor Miller teaching civil procedure. He's not only the top of his field, he's a good, clear speaker who gives good, clear examples. I feel like he's just top notch in terms of an instructor. So hopefully he explains things in a way you can understand, even if the material is complex. And certainly, well, we'll get to it later, but we've had people who come from foreign countries where they have, nothing resembling US civil procedure, and they pass just using our course. So obviously they've put in the hard work, but they can get the material they need from Professor Miller and from our outline. That's the second great benefit you have. Our outline, the BarMax outline, covers all of the material that NCBE says it might test and that we've seen tested. And third, what we will focus on today is using past essay questions. I'm going to talk about this essay question in a minute, but I just want you to see what they look like, especially for those of you who are not taking the UBE and haven't looked at these MPRE, multi-state essay questions before. We get a big old fact pattern and a couple of questions. That looks familiar, right, to law students and students of the bar exam. But what I recommend is that we go through, we're going to do this together with this question. We're going to model this. We're going to read the calls of the question and the facts. We're going to take notes and figure out what rules apply. Now, if you've been paying attention to my advice, we promote an active study method for MBE questions. And the same thing applies here. When you have this question in your hot little hands, you're going to use that opportunity to review your outline. You're not using this question to test what you remember. You're using this question to learn and reinforce the material in the outline. I want you to think about these questions as your BarMax school hypotheticals. These are the hypothetical questions that you need to wrestle through with the rules in hand in order to really understand how the law applies. You'll ask yourself which facts are determinative, which ones matter and why. And then for each question or issue, or maybe even sub-issue that you identify within each question, you'll draw a conclusion. Now, if you want to, you can go ahead and outline an answer. You can even write an answer if you feel like you're still working on that. Knock yourself out. But if you're not taking the UBE, just, find the rules that matter, note the applicable or the relevant facts, and draw a conclusion for each question. And then, number 3 on this list, go to the Ncbi Analysis. Look at this beautiful thing. This is not an answer or a model answer. This looks nothing like, look, it's 4 pages. People who take the MBE have 30 minutes to do an essay. What they want to do is they want to hit these points, okay? Boom, boom, and boom. This one had 3 issues, okay? If you have hit those issues, and as you read in here, you'll see rules and facts. Now, there'll also be all kinds of background on the law and long quotes from Supreme Court cases, and maybe in real property, majority and minority rules, and blah, blah, blah. What you want to focus on when you read this analysis is not even all this stuff up front. You want to focus on the stuff down here, okay? That includes the rules and the facts. Because if you knew the applicable rule and you identified the determinative facts and the outcome, then you understood what was going on. And if not, this is your chance to learn the law. Okay, so do you see? I'm hoping you see how we should use these essays. We're going to go back to this particular essay in a moment, but I wanted to kind of talk you through the process that you should be using. Now, again, the multi-state essay exam is written by Ncbi, the same organization that writes your multiple choice questions. And before it showed up on the multiple choice exam, civil procedure used to be tested on every MBE, every essay exam. It's still a frequently tested subject. It's been tested on all but 4 exams in the past 12 years. So we have dozens of real life fact patterns and those rich, lengthy Ncbi explanations to work from. Now, again, if you're a BarMax UBE student, all of those essays and explanations are included in your welcome packet. You'll look under model answers and then pick point sheets. And the point sheet is this, okay? And when you pick point sheet, it gives you the question, so this page here, and then the Ncbi analysis or explanation, which we call the point sheet, because it also kind of divides the percentage points that they recommend the graders allocate to each issue, okay? But if you are a BarMax California student or just purchased the MBE program, we want you to reach out to support and get a packet of these essays from us for free, because we feel like If we say it's the best way for you to study for the MBE, then we want you to have it in your hand. So we've bundled 18 questions and explanations from February 2009 to July 2019. It's in a zip file, and you just reach out to the support and they will send it to you. Just quickly what the welcome packet is. Oh, I can't show you here. I can only show you through the website, and I don't have the BarMax website open. But if you go to the BarMax website, wow, my screen is loading very slowly. Yeah, we both working from home using the same internet right now. Anyway, if you go to the website of BarMax, this is important because you do need your welcome packet, whether you're California or UBE. It's under your profile, that little picture of a person's head. You download your welcome packet there. So again, if you are any one of our programs and you want those essays, reach out to support and they can give it to you. So let me scroll down. So we've talked about we've given the overview of how to use these essays effectively. Now, let me talk about the topics covered. There are a lot of essays, not surprisingly, that touch on jurisdiction, either subject matter jurisdiction or personal jurisdiction. There are a lot on Joinder, which I'll get to in a minute. But then there are many other topics where we have just one essay in recent years. And the one I posted for today, February 2014, is actually one of those essays. It's our only essay that has dealt with issues of discovery. Let's follow our method and look at the cause of the question first. Should the court order the customer to turn over the engineer's report? Okay, so someone is requesting some particular discovery, some particular item in discovery, and the other party objects and has a basis for that objection, and will and we need to determine using the rules of discovery whether the court should order the person to comply with their request. And then number two, should the court sanction the builder for destruction of emails related to the case? And if so, what factors should the court consider in determining those sanctions? So these are both discovery issues. Now we could read the whole thing. It's about a builder and a customer and some problems, and there's an engineer's report here at issue. If you were doing this for real, you would take time to read the whole thing and take some notes. But I'm going to cheat for time today. First, and just get to the last two paragraphs. Okay, there are two, because I know what this says. 2 discovery disputes have not yet been resolved. First, despite a request from the builder, the customer has refused to provide a copy of the report provided by the structural engineer, I'm reading here, who examined the foundation of the house. The customer claims that the report is work product and not discoverable because the customer does not intend the engineer to testify at trial. The builder has asked the court to order the customer to turn over the engineer's report. Okay, so this is the motion that goes with this question here. Okay, question 1, that is a very fat arrow, but you follow. Second question, the final paragraph of the facts here, the customer has asked the court to impose sanctions for the builder's failure to comply with demands for copies of all emails concerning construction of the foundation of the house. The builder has truthfully informed the customer that all such emails were destroyed on August 2nd. Ooh, whenever you see a date, it's usually important. So when you follow the fact pattern along, you'll see things happening on different days and you'll relate. Okay, is August 2nd relevant? Where does it fall into the flow of these facts? Where does it fit in the storyline? This destruction was pursuant to the builder's standard practice of permanently deleting all project-related emails from company records 60 days after construction of a project is complete. There is no relevant state records retention law. Okay, so we have here a question of possible work product, and we have here a question of possible spoliation of evidence. So over here in the civil procedure course, we would not read all of our facts and then try to answer it and jump straight to the NCBE answer. We're saving the NCBE answer for last. Instead, we go over here and we go, aha, we have a whole lecture that we listened to of Professor Miller on discovery and pretrial motions. And now's my chance to review the outline of that lecture. You may end up reading the whole thing, but you're definitely going to read the part on work product. Okay, you're definitely going to read the part on work product. Okay, material, which applies to materials prepared in anticipation. Okay, and you're going to, in anticipation of litigation, I'm sorry, the work product doctrine doesn't have to be by an attorney or a lawyer. It can be by any party as long as it's prepared in anticipation of litigation. Got it. We would reread the rules around that issue at this time while we're reviewing it with a fact pattern to hang it on. Because we don't have that many fact patterns, right? We don't have a ton of MBE questions. So we're going to learn everything we can from each fact pattern. We're in the dispute because remember, when you do this, you'll read all the facts. You're in the dispute between the builder and the customer. By the way, you can do this if you're not a BarMax student, because some people are frustrated. They say, well, I paid for this other bar review program and I'm not sure I'm getting my money's worth, or I couldn't afford anything or whatever. For whatever reason, you're not a BarMax student. NCBE does publish these. I meant to mention that earlier. Okay, they publish their old essay exams, and you know, they publish the old essay exams, and there are 4 years available for free. And the 4 years that are available for free, I think they include 2014, which means you can get this particular essay. And then other years are available, but you have to pay for them. So you get more years with BarMax, but you do get past essay questions with NCBE. You can go download some for free. Now you have to download the whole exam if you're a California student and find the civil procedure question and study from that. But you know, if that's how you want to do it, you can do it that way. I want you to use these questions either way, because these webinars are supposed to be helpful to everyone. Anyway, sorry, I got a little distracted there. We were on work product, and then we look on different discovery tools. We have requests, and then we have enforcement. When are sanctions appropriate? So what we would do after doing our best to answer the work product part of the question, we'd come back into our outline, we'd read all the rules around sanctions, we'd go back to the facts and try to figure out, like tease out as much application of law to the of law to the facts as we can. We would want to find all the relevant facts and figure out which way it would go, because this one is going to be one of those things where the court has to make a judgment on sanctions, and a failure to preserve electronic information that applies to emails would apply here as well. So when you do this, you'll use your bar prep materials, either your BarMax book, which has the same outline in it, or your BarMax outline on the app like I'm looking at here, or you'll use the materials that you have, but you'll go back, you'll read everything you can about work product, about sanctions, and about failure to preserve electronically stored information. And then you'll go back and you'll do these steps, as we said. You're going to draw a conclusion for each question. You can write it out in a little outline, a little skeleton if you want. And then you read the Ncbi Analysis or point sheet. Again, like I said, the most important parts are the points, point 1, point 2a, and point 2b. The introduction is actually less helpful than the parts that contain the rule and application. Okay. And then finally, you're going to say, aha, I learned something new here. And you're going to go back and take notes. Now, if you keep a notebook with your own rewrite of the outline, which some people do, or if you scribble all over your paper outline, which some people do, or if you just have some massive stack of flashcards and you're going to add something to it, you may not be at that point of your study, that's okay. But if you are, whatever format you want to put down where you can remember it, anything new you learned from the problem. So I just walked you through how I would do that with the February 2014 question, which is the discovery question. I want to talk about a couple more questions, although that's the only one we're going to walk through in detail. There were civil procedure essay questions on the last 2 exams. It is still a frequently tested subject. Last July's question was tough. First of all, it was a crossover question. A crossover question is one that deals with 2 subjects. Okay, so crossover, 2 subjects. This one happened to be federal civil procedure and constitutional law. This was July 2019, okay, on the bar exam that was administered last summer. This particular essay had 3 questions. One was about whether the federal court had jurisdiction. One was about whether a particular state procedural rule should apply. Hint, hint, eerie. And one was about standing. And standing is, of course, a constitutional law issue, whether this is the sort of case or controversy that belongs before a court to begin with. So, so far so good, right? Jurisdiction, whether state rules apply, and standing. What threw people off was that the question was about a class action lawsuit. Class actions are covered over here. I might as well open it because we're going back to it in BarMax Civil Procedure Lecture 5. Joinder. Okay. And this is all about joinder of parties and claims, the way that different people can be brought into a lawsuit, the way that different people can barge into a lawsuit if they want to be there. And then Section 5H, the different, the requirements of class actions, and what you have to do in a class action, the jurisdictional issue, and then the Class Action Fairness Act, okay, which is a statute that grants the court subject matter jurisdiction over a wider range of class actions than it would otherwise have. Basically, very large class action lawsuits can get into the federal court under the Class Action Fairness Act, even if they don't meet the court's federal question or diversity jurisdiction. They have to meet these other requirements instead. Fine. Students who were unfamiliar with the different kinds of class actions, students who didn't know about this jurisdictional door that the Class Action Fairness Act opened up, they tackled that first part of the question, the court's jurisdiction, as if they were just considering federal question and diversity, and they got the question wrong and didn't do well. And people had trouble with the standing issue too. Most people got the Erie issue right. At least, you know, I'm talking to retakers. I don't know. Obviously, for the people who passed, they may have done better. So I'm going to tell you, that one was tricky, right? But we know that Ncbi tested the basic rule for class actions in one of those 46 released MBE questions. And now that we know, it has also tested the Class Action Fairness Act in that July 2019 essay. Doesn't that motivate you to know the rules for class actions? Do you think they might get tested on another MBE question? I sure do. They're laid out in the BarMax outline section 5H. You want to know them. Okay, in February 2020, there was another civil procedure question. This one was straight up joinder. Again, we're here in joinder of parties and claims. It tested, you know, what permissive joinder, whether, you know, a plaintiff could sue a bunch of defendants at the same time, and it tested impleader or third-party claim, you know, can a defendant drag another defendant into court on that lawsuit? Some students told me, whoa, it was joinder. I was caught off guard, and I don't see an excuse for that, because these issues, joinder, impleader, were tested in, one of the issues, impleader, was tested in a released MBE question that we have. Again, we only have 46 questions. If one of them is impleader, you should know impleader. But joinder was tested on essays in July 2008, July 2009, February 2010, February 2011, and February 2015. That's 5 questions since 2008. So I feel like anyone who got caught by surprise that there was a joinder essay didn't review MBE essays as part of their bar review, or maybe they just reviewed a few. So that's why I'm really a big proponent of people review what we have, because those essays are teaching us what they like to test. Now, again, I'm going to tell you, for some subjects, we only have one essay, that one discovery essay. We have one preclusion essay. We have more than one preclusion MBE question, so I know you will see it on your MBE. But preclusion was tested in one essay question, February 2013, and let me tell you, that question is good, and by good, I mean difficult. It tests both issue preclusion and claim preclusion, okay, res judicata and collateral estoppel both, and it tests the, you know, both the defensive and offensive uses of issue preclusion, which is a particularly tough issue. That makes it a particularly tough essay. This is the sort of thing where I've had students I was tutoring, and they go do that essay, and then they come to me with more questions, because preclusion is that tricky topic for them. So I would say that about this essay. There's also one essay that deals with intervention, that's a joinder issue. That's when a new plaintiff wants to barge into the lawsuit, but it also dealt with TROs and injunctions. So if people are doing these essays, if you're working and through your bar review and you decide that some of these less tested topics in civil procedure are still like bothering you and they don't make sense, that might be a good time, right, to start thinking about tutoring. Because if you want to use a little bit of tutoring strategically, the way to do it is to purchase your tutoring now and then schedule it when you have some questions you want to go over. You can communicate with your tutor in advance. When you sign up for an hour, it says, you know, like basically there's a box to write what you want to review. And so you can say, I did that preclusion question, help, you know, or let's talk about preclusion. Okay, so the other things, let's see, you should know those things. There is one essay on appealable orders and the final judgment rule. Again, another tough one. We have one essay on it. We have one or two past, you know, MBE questions on it in that set of 46. So you're gonna see a question that asks you, can this party appeal at this point in the litigation? Okay, normally it's final judgment as to all parties, all claims. You need to know that, and you need to know the exceptions to it. Review your outlines, learn the law, but then use that essay to learn the law. You also want to make sure you understand motions for summary judgment and the standard for motion for summary judgment, the standard for motion for judgments as a matter of law, JMOL, because we've seen MBE questions on those, so we already know they like to test those on the MBE. Okay, so we're encouraging you to use the essays because they should really help you understand and learn those doctrines without resorting to fake questions written by employees at bar prep companies or law professors who are distant from the bar exam when those questions don't resemble questions tested on the bar exam. And then I have one more thing I want to cover before I launch into Q&A. Sometimes you will see a question on the MBE that asks you something that seems procedural, but is not actually a procedure question. For example, you might get a question about jury instructions. And sure, there are some rules regarding juries that are covered in civil procedure, and there are some specific types of jury instructions that are covered in evidence. But when you see a question that, you know, a fact pattern about a particular tort, and then it says, did the judge properly instruct the jury about the, you know, assumption of risk defense? Okay, that's a torts question. You need to know if assumption of risk is an appropriate potential defense for the tort at issue, and you need to know whether the statement of law that the judge made to the jury is correct. So that's a torts question. It's asking you to identify an issue of law, and it needs you to know torts law. So it looks procedural, but it's a torts question. And again, you can have that kind of question, a jury instruction question and crimes question, but then you know it's not civil procedure because we're not in civil court. So you'll know that it's about crimes. It's about either an underlying crime or defense, or it's testing criminal procedure. So there are jury questions tested in civil procedure and in evidence, but not every question that mentions a jury is procedural. Some of them are substantive, contracts, torts, the like. And that's similarly, the same thing can happen, for example, in a motion for summary judgment. Okay? You need to know both that summary judgment is appropriate when there's no triable issue of material fact and proponent is entitled to judgment as a matter of law. Just get to where you can rattle that off, okay? You need to know that, but the question might be testing the underlying law, not the procedural part of the question. So ultimately, it doesn't really matter whether the question is classified as a civil procedure question or a contracts question, as long as you know the underlying principle and you get it right, right? So with that, I'm just about to move to my Q&A. It looks like I have 11 questions that I hope are on topic. If it's about preparing for civil procedure, I want it in Q&A. And if it's anything else, throw it in chat. And then finally, I keep saying it's the last thing. It's almost the last thing. This is the last webinar for the July bar prep season. Next week, I'm going to be transitioning to doing some office hours. Tentatively, it looks like I'll have 1 office hour a week, but those are for BarMax paid students. And so we're going to start those next week. So you won't not see me. We're coming up with some topics and planning a schedule so that we'll be here to answer your questions ongoing throughout your bar prep season. And I wish you happy studying, persevere. Okay, all the best. I forgot I'm answering these questions. Does this topic apply to the California bar exam? I think I answered that live. Yes, it applies to the multiple choice portion. Any flashcards with rules you can recommend? Yes, I recommend the BarMax flashcards. I guess I can show you some civil procedure flashcards. These are more of our old style flashcards. Oh no, these are question and answer. Is there a right to a jury trial? No, it's law and equity, and equity, no, law and equity, yes, as to the law part, blah, 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 right? So these are flashcards done in question and answer format. We've got that now for all of the MBE topics, except for torts. We're in the process, literally, like our development team is in the process of uploading the new style question and answer style flashcards now. And then we're also uploading a set for remedies, which can be tested in any one of several subjects on the MBE, and that will be a full MBE set. When we have all that up and going, we are going to offer that for sale as a separate product for people who just want good flashcards for the MBE, but that's not ready yet. And all the rest of them, everything civil procedure all the way down to real property are great right now in BarMax, and torts are so-so. In my view, we've upgraded them and they are going to be available very soon. So yeah, if you do not answer, can a corporation be a citizen of 2 states? Yes and yes. Okay, so this is a question about diversity and it's an easy one, so I'll answer it. So if the corporation's principal place of business, principal PAL, Amanda, place of business is in state A, and it's incorporated in state B. It's a citizen of both states. So it does destroy diversity if plaintiff is domiciled a citizen of either one of those states. So yeah, that's a good jurisdiction question. It comes up in a lot of essays for sure. Only has multiple choice. The MPRE, yeah, that's, yeah, I think Joe answered that question. There's no civil procedure on the MPRE. And then where is this analysis, the one that I showed, found? So if you have the BarMax UBE app, you download the welcome packet and you look under the MBE essays, model answers, point sheets. And you'll find them all there by year. MPRE is generally the code of conduct and ethics. Yes, the MPRE exam tests ethics. That's not the topic of today, but yes, it tests professional responsibility of lawyers. Is this particular essay question and in our welcome packet? Marie, if you are a UBE student, yes, it's in your welcome packet. If you are not a UBE student, Marie and the one before whose question I answered, if you're a California or MBE student, reach out to support. Make sure you're using the same email that you purchased with. We can confirm your purchase and go ahead and send you this question and 17 more that you can use to study from. If there is a contracts issue in an essay, fairness factors. Okay, this is a little too, Rima, I'm sorry, this is a little too specific. So I would say rely on the actual fact patterns that we have in those essays. Yeah, and if you have a, you can reach out through support, hit the headset if you have a content question, that I've been answering them, within a few business days. So this anonymous, I was using MBE essays, and the reason I recommend those to everyone as study tools, not as model essays. Don't use them to learn how to write an essay. Use them for California students. Use these essays to learn the type of law that you are likely to see tested on the MBE, on the multi-state bar exam. It's an MBE essay, meaning from the UBE, the Uniform Bar Exam, not a California essay. And we know you don't have those if you're a California student, so go ahead and reach out and we'll send the packet. Okay. Okay, so Rima asked about this thing where somebody wants to do a renewed motion for judgment as a matter of law, but there was no motion for judgment as a matter of law. We know from one of the prior MBE questions and from the rules in the outline that will fail because you need to do, you need to have the prior motion first if you want to renew it later. And if it's in an essay, should you discuss the standard or just state it should be renewed? Probably you should state the standard. I'm thinking of a different civil procedure question where it tested what someone had filed a motion for dismissal based on ineffective service of process. Well, the motion wasn't timely. If you want to file a motion for dismissal based on ineffective service of process, it needs to be in your first response or pleading, first motion or pleading that goes to the court. Okay? And this wasn't, this came later. So students who just said, oh, it came later, it's denied, got it substantively correct, but left points on the table because there were points available for discussing what constitutes effective service of process, why this service of process in this particular question was pathetic and inexcusable. No, I mean, it was. You can't, under the federal rules, leave, the summons and complaint as somebody's work. Can't do it, right? Even if you have the right kind of person serving it. So you had to point out what the rule was, why it didn't meet the rule, and then do a however. It's also necessary that they file this on time and this party didn't. So the motion should be denied. But you couldn't just do one step and not the other. You had to show off your knowledge of the actual standard and why service of process was inadequate in that particular fact pattern. But that's about essays. Again, for multiple choice, you would get it right. You know the rules either way. No answer explanations in the hard copy supplements. I am not sure. Oh, the hard copies are just for testing, Marna. Like use them like you would use the test. That's what those are for. You have to go in and type them in to see the wrong answer explanations or the right answer explanations. And you can look them up online. You just go to the same part of the OPE, just go to the same OPE and type in the answer in the same place and you'll get the answers. But we give you the book so that you can take it as a live real exam pen, with a pencil in your hand. If that's how people take the exam, often they prefer taking their practice exams that way as well. And then further information on the flashcard questions. Okay, so the places within BarMax, Julie, to get further information are in the answer explanations that we saw today from Ncbi, the point sheets from Ncbi that provide solid, thorough analysis of all the issues. If you're saying about supplemental jurisdiction, it's covered in several past MBE questions, so you can look there. You've got flashcards, you've got the outline, you've got Professor Miller's lecture, and then we also have tutoring available if things are still sticky for you beyond that. There's also, you can click support and write a substantive question, and it will get bounced over into BarMax content. At this point, I'm able to answer most of them within 2 or 3 days, but you have to remember it's a shared resource. If I get, 5 questions from the same person, we recommend that that person seek tutoring instead. So if you are stuck on something, go ahead and send me a question. But if I get swamped, I prioritize the people who haven't had an opportunity to have questions answered yet. That's all. It's not that I cut you off. It's just how I have to prioritize my question answering time in the day, because I'm also working on doing webinars and office hours and building out great BarMax content and tutoring and grading, and I do love my job. So approaching California federal civil procedure, that's actually great, and talking about the distinctions. You want to be using, obviously, the California version of our outline has the distinctions in blue, so they stand out, and you want to study from the California essays. I think it's good to study from the MBE essays too, because they'll show you kind of what's more likely to be tested on the MBE, but the California essays, they test specific topics over and over again over there in California. And those essays are in the same format as the essay questions that you'll do, Amy. So that's the part of the question. So I do recommend studying from past California essays for that part, and learning the distinctions in context. It's good to have the distinctions lecture separate, but I think learning them in context so that you know them side by side. The first bar exam I took, I remember I had to know state law and federal law. I had a big chart of the rules of evidence, and the things that were the same were in the middle, and then the things that were federal and Massachusetts is UBE now, but my first bar state was Massachusetts. I had arrows going off to the side to remember, which was which. Like, here's what's different from the federal rule. I'd have a little arrow going over to Massachusetts. That was one crazy looking chart, but it worked for me. It was stuck to the wall above my bed, and it might be that flashcards work for you. So whatever it is that helps you to memorize, whatever's worked for you in law school or in the past, that's what we're going to recommend when you're studying those distinctions. But I think it's good to learn the law side by side so that you'll know, oh gosh, what is it? You guys call an excited utterance something else in California, right? I don't know. There's like one of the hearsay exceptions is pretty much the same, but it has a different name. Like, you need to know these things. and you want to have them side by side in your notes. Amy, that was a great question. Okay, so when there is a discrepancy between the outline and the lecture, it's because the federal rules of civil procedure and the California rules of professional responsibility have both been updated since we've been able to, have re-recording and editing and uploading of lectures. So when there is an update to the rules, we put it in the outlines right away. So if there's a discrepancy, it's usually, there's a couple deadlines that changed. Okay, they're correct in the outline. They're correct in your 2020 paper outlines. They're correct in the online version of the outline. But yeah, there's a couple of places where, Arthur Miller's lecture, like we can't go tug on his sleeve every time there's an update. We will, eventually, work in the updates into the lecture, but we do work them into the outlines immediately. Even there was a Supreme Court case that slightly altered something within criminal law, and it was changed on the outline within a week or two, right? We get that live as soon as we can, even though it's not going to be tested for a couple of years because of how long they take to vet questions. Yeah, so trust the outlines as the more updated source. Catherine and Garrett, that was a good question. For crossover questions, do they typically cover 2 subjects or can they cover more? That's a good question too, Marie. This is not about civil procedure, but oh well. It looks like I can get to these answers. Yeah, I'm not going 2 hours today, guys. So let me just see if I have any more. There's one more Civ Pro question. I'm going to scan through and get my Civ Pro questions first, and then beyond that, I'll do what I can. Crossover questions on the MPRE are 2 subjects. Crossover questions in California have occasionally been 3. Okay, 2, sometimes 3. Makes sense. California, you have a lot longer. They'll throw professional responsibility into almost anything. Yeah, so you'll see when you do California how they categorize their essays. But on the MPRE, they're not particularly common. I can think of one that's agency and torts. It made sense. It was a big respondeat superior issue. I can think of one that was, oh gosh, I was just thinking of a particular question. It escaped my mind. Oh, it was secured transactions, but property, real property, because something became a fixture. And then when the fixture, you got to run file that in the county records. And that's, the fixture filing is a real property concept. Sometimes there's a conflicts of law issue that is embedded in some other topic. Conflict of laws is never tested on its own. So yeah, it's usually just 2. At one point, should you start memorizing flashcards? Okay, so we recommend that you're going, first you're learning the law for comprehension and understanding. And then sort of your second time through, you're creating those memory tools, those flashcards, those mini outlines, your memory tools that you will use to cram. And all that cramming really comes in the last 2 weeks. So yes, you'll be creating your flashcards, but you'll be cramming those flashcards in the last 2-3 weeks, and even in the last couple of days, not the Monday of exam week, but Friday, Saturday, you'll be cramming those things, and you'll just be reviewing some essay fact patterns and not stressing your mind out too much, just reviewing some essay fact patterns, reading the answers, taking it pretty easy. So yeah, you should be memorizing the flashcards, I'd say the last 3 weeks, Danny. Oh, Nasheen, reading the MBE questions themselves. You are right. The MBE questions can be deceptive because, especially in Civ Pro and more even in evidence in particular, every word matters sometimes in one of these MBE questions. So you need to really figure out what's going on in the lawsuit. Who filed the motion? Why? You know, is it a civil or criminal case? And you know, what claim or defense is at issue here, and who filed the motion and why? And if we try to do them without thinking through all of that in a procedural question, whether CIF pro or evidence, it can be very tricky. So, and the questions are tricky. And it's, I mean, if you're an international student, English isn't your first language, perhaps, I don't know if that's true. But you say you're an international student, maybe just didn't learn the law with the same terminology. I find a lot of native, you know, like a lot of American-born, English-speaking, American-trained lawyers have the same problem because these questions can be so tricky to read. So I think just keep practicing. Just keep practicing, Nisheen, and persevere. Where can I find all the dates needed for questions about timelines to serve? They're in your outline, Patrick. And if you like to like keep them all together, I recommend you go through with like a color highlighter that you won't use anywhere else, like pink or, you know, vivid green or something, and just mark them all up, because the ones in the outlines are correct. The TRO can last 14 days, and you know, you have 90 days is the relation back period to add another defendant and so on. So Indiana bar takers, oh gosh, Amanda, it's funny, I am actually physically located in Indiana, and I would say this is really kind of sneaky, but Texas has always used short answer questions. So go to the Texas Bar website, okay? You don't need to know their law. You don't need to know, you know, don't get distracted by what it's even about. But for format, they might do something like Texas, right? So go to Texas and look at the PMP, pleadings and practice, PP&E, pleadings, practice, and evidence. They have a section of their bar exam that's short answer like that, okay? So take a look, maybe yours will be in that format, and you just want to know, you know, so you could imagine at least what your questions would look like, and, you know, try to talk yourself through what some of the fact patterns that come from the study materials that you do have would look like. And the other thing to remember, Amanda, is that everyone in Indiana has the same disadvantage. Nobody knows what the heck they're doing, right? Nobody knows what the Indiana bar has come up with or is working to come up with as we speak. We really don't. This is an interesting time we live in. So at least you'll be on level ground with your peers. I would say take a peek at those Texas procedure questions just so you can see what might be the format. I can't promise it will be, but it's actually a pretty good format, I have to grudgingly admit. It's the sort of thing you either know it or you don't. It's brutal. Texas was my second bar exam. All right, thanks, Amanda. If you've been out of school for 5 years, I'm going to assume you're starting now. You say you have not looked at any legal material or been in the legal profession. Can you prepare by September 9th? Yes, Anna, absolutely. If you're willing to put the time into it, you can. It's going to take you some time and some focus. And if you're having trouble with analysis and need practice, I should really be here. When you buy either the UBE or California program, you get this 10 free essay critiques, okay? And you want to use those. You want to send an essay in, wait for feedback, incorporate the feedback in your next essay, send another essay in, and really work on your analysis that way. Oh, you have the California program. Anna, thank you for letting me know. So that is available with either the UBE or the California program. You should be sending in essays and looking at those sample answers that California students have done, so you see what sort of analysis has been given a lot of credit before. And then if you need more essay critiques after that, you can purchase them. They're $30 for one, or a package of 10 for $200, which is a really good deal because you're basically getting tutor time. These are our graders, and our tutors tend to overlap a lot, you know, and there are definitely people at the same level, you know, to critique those essays and give you feedback. You want to get all the feedback you can and keep working on it. So you might need to do another 10 after that. You're welcome, Anna. Read the call to question, read the relevant portion of the outline, write a quick outline to make sure you have it all correct. Yeah, but you're also focused on the facts. The only thing you left out there, my anonymous friend, is make sure that you're also really focusing on the facts, you know, okay? So you might want to screenshot this or something. Sorry, there you go. Okay, that was for your screenshot. Are the essay tests given more weight than the MBE? Matthew, it depends on your state, but for the UBE states, it's 50-50. For California, it's also 50-50, but that's writing versus MBE. And the writing is both these substantive essays, like the one we looked at today, and a performance test component. For the UBE, people have 2 performance tests. For the California exam, they have 1. In each test or task is 90 minutes. So that is incorporated into the writing half of the grade. Now, some other states that are not UBE or California may weight things differently. You need to get to know your state. And actually, I did a webinar about the different states at one point. You can go find it. But Matthew, you're probably UBE or California. Do we provide model student essay answers? Anonymous, probably different anonymous, but another good question. Yes, we do. It's in the welcome packet. For California students, California has been providing these a long time, and we have them there with the essays. They're called sample answers or model answers, I think. For the UBE students, we have some New York and some Minnesota answers, because those are 2 of the states that have released answers since they've had the UBE. And so we have answers from about 2013 to the present, so you can see how another student answered. Here's my caution about sample answers, okay? You know that that student scored high on this question. You don't know that they got to every question, right? Maybe they only had, 5 pages of wonderful stuff here, or 12 in the case of California, because they were misallocating their time and didn't get to question 6. You just never know, right? So don't let them stress you out. Use them as a guide for some of the things you may have excluded from your essay, but you think about what's reasonable to do over all the essays you have to do, 5, 6, in the allotted time. And yes, they're within BarMax, they're model student essay answers. 90 days, Rima, in the outline. The outline is the more updated source. G10. G10, I would say the advice for civil procedure in the October 2020 DC bar exam is exactly the same as what I've given now, because the DC bar exam, which DC announced yesterday or this morning, I think yesterday announced would be online, is going to be the Ncbi. I don't know what to call it. It's a mini bar exam. It's not a UBE anymore, but it's composed of the same components as the UBE. So Jiten, for you'll have half your exam will be MBE questions, these same multiple choice questions that today's webinar would help you prepare for, and half will be essays, and there may be a civil procedure question among those essays. So, essays and procedure. Now we got people making friends in Q&A. You were supposed to do that in chat, but that's all right. I'll forgive you. We have great students. So let's see, I finished that one. Let me scroll up and see if I missed anything. I answered that one. Charles, how late can we realistically start for September 2020? Oh boy, you're one of those people who really likes to ride the line. You're clearing your schedule. I don't know. It's really individual. Like I personally, I'm a little older. I probably can't sit down and study for 10, 12 hours a day. Like my brain is not going to be effective. My body might be there, right? So you need to think about how effective your brain is in long periods of study. I always recommend that my students break up their study periods into chunks and, have a goal like, for this chunk, I'm going to accomplish this or that. And so you would be doing multiple chunks in a day under the method you're recommending. You also want to see what your starting point is. If you are a BarMax, UBE, or California student, maybe you want to slide into OPE1 right now and just see where you're at. Where's your starting point? And maybe, turn in an essay. What's your starting point? And that way you can gauge how much you need to go, right? You need about, depending on what state you're in, you might need 62, 65 out of those 100 questions to be within range of passing. We've talked about that in other webinars, but you can be a little higher in the writing and a little lower in the MBE or vice versa. Oh yeah, you're California. So yeah, California's rough, man. Charles, like it's got a high cut point, it requires, it counts everything in, thousands instead of hundreds, but it's, it's a very demanding exam. It requires you to score pretty high. So you want to make sure that you give it enough time that you're only doing it once, or only one more time. So I don't know. The answer is I don't know. It's really up to you. Even if you can be knocking out a little bit between now and then and breaking it into chunks, or maybe you just, have that brain that's effective for 12, 14 hours a day. I have been under intense pressure, but I don't like it. And then I get sick. Anyway, good luck to you, Charles, either way. Can you sue a foreign corporation in federal district court? Yes. And yeah, and your question was skipped. Sorry, Ida, because I was looking at studying for civil procedure. And yes, the personal jurisdiction over foreign corporations is covered in Section 2, personal jurisdiction, part of the civil procedure materials. Apologies for skipping. And then let me see if there's anything else. California Civ Pro, I answered that. Do you have to discuss Erie every time? Good Lord, no. You only have to discuss Erie if it mentions a state law. You have to determine whether that state law, if it says something like, gee, should this rule about arbitration or this rule about class actions or whatever, should it apply in the federal court? And then you have to determine whether that rule or law is substantive or procedural. If we're in the federal court, in state A, the substantive, on a state matter of state law, the substantive law of state A will apply, but the procedural law of the federal court will apply, because when it comes to procedure, home court rules, right? So wherever you're sitting in court, that's who rules. So you'll only have to discuss Erie on those issues where you know, a state rule, whether a state rule should apply or not is mentioned. And I answered that one, and I think I am done. Oh, Nishat, absolutely use a laptop. Absolutely use a laptop. We discussed it in an earlier webinar. So Malcolm, I just told another student I'm a little older. I'm a youngster, and I commend you for tackling this. And we don't have past stats. We have another student. Didn't we have some older student who just, no, we have another one who just signed up. I think it wasn't you. Maybe it was you. Anyway, I would just say, you know, look, you know what works for you. The advantage of being older is that you know yourself a lot better than young people do, and you know what you're capable of. So you make yourself a schedule that's going to work for you, and you go for it. And let us know. We want to hear all about your success. Okay. Let's see. Marcos just tells us that he's younger than I am. Sorry. Sorry, Marcos. He said his age. Kieran feels older. Look, Malcolm was 74. So none of us are calling ourselves older unless we're older than 74. You can complain about your age if you're 80 or above. Otherwise, you're a peer of Malcolm or a youngster. Malcolm, is that okay? Any special tips to help repeaters? Oh, wow. Yes, Julie, I just remembered this. If you have your essays from your old exam, we've been talking because a lot of people want us to review their old essays. So if you were a BarMax student at the time you failed, look, we're here for you, and send us your essays, you know, through the support link, and I'll take a look at them if it's UBE, or I'll grab a California tutor if it's California. Okay, so yes, we have special help for you. That $50 hour. California Civ Pro always tested when Civ Pro shows up in the California bar exam. Estefania, I am sorry, I don't know the answer to that. Mostly because I'm not California focused. I don't, you can see I've like memorized the UBE questions, but I am not as familiar with the California ones. If there's always, it wouldn't make sense to me. Estefania, think of, you're either in a California court or a federal court, right? So if you're in a federal court, federal procedure applies. If you're in a state court, state procedure applies. So the only time I could see both coming up in the same essay would be like if there's a removal in the middle, you know, removal, the process of removing a case from state to federal court. But other than that, I guess they would be separate because of what court you're in. So I just figured that out by logic, Estefania, but you should be looking at old California exam questions. How would you recommend studying part-time if you work and have young children? Evan, you would not be the only one. No, you are not alone in this, and it does take a lot. It is extra special. I find that people who really, you know, I mean, you know, because you work and have children, it's about plan your work and work your plan. Plan your work and work your plan. You know, if your kids go to bed at 8 and, you know, and you're the one handling bedtime, it depends who handles bedtime, right? Then, you know, maybe from 8 to 10 is a good study chunk for you. Maybe 90 minutes here and 90 minutes there, and you tack it all together. You give yourself some more time on the weekend when your, you know, spouse / partner / babysitter / fairy godmother can, you know, work with your kids. And you know, you've had to do it to get through law school, right? You had to fight for your time and plan your work and work your plan. So I've seen it work for people. It's just, you know, it's complicated, right? It's complicated. You know, I've had other students who like, you know, have to avoid going out to the bars so much, you know, it's a different life. Yeah. Everybody has an easy time with that now that the bars are all closed. Anyway, I guess it depends on your state. Never attended law school and have never had a law essay graded by a law professor. Laura Pantasis. Oh, I'm sorry, I said your whole name. it's just interesting name. Interesting quandary. Never been to law school. So I don't know if you're one of the California, people coming in under this supervised exemption, and you want more essay grading. I would say reach out to BarMax. Use the discount in today's email, the email you'll get after the webinar, and buy essay gradings. If you're our student already, you have 10 essay gradings. But if you are not our student, you can still buy essay gradings a la carte. So, buy a packet of 10 for $200 and start getting feedback on your writing right away. Also, look at the samples so that you know what people are looking for. And I was a law professor, right? So if I get one of your essays, it'll be graded by a law professor. We also have former bar graders and just phenomenal people working on the grading. If you're California, we have somebody who's just giving great, helpful feedback right now. So yeah, get some essays in for feedback. Are there topics in Civ Pro that are likely not to be tested? Victor says, what should I skip? We put it in the outline because we think it's going to be tested or it could be tested. So the answer is don't skip anything, Victor. I know you didn't write what should I skip, but come on. Is there special assessments or tutors to look at old exams if you're repeating? And I answered that one, yes. And do you have to have 2 aliens on both sides if personal jurisdiction of 2 U.S. citizens on both sides? Evelyn, that sounds like a no, but I'm not sure I understand the question. I am sorry. Yeah, personal jurisdiction, lecture 2. Just review it and the MBE questions. And there are a couple questions that involve foreign corporations in that set of MBE essay fact patterns. Kieran wants to connect with all the people who've been out of law school for 10 or more years. 10, psh. Anyway. Yeah, anybody wants to connect can try to do so in chat. Laura gave her email to set up a group of you. I'm leaving Laura's question open here. Okay, so everybody got in touch with Laura. At 78, will you be the oldest to pass the bar? No, I've heard good stories. Wait a second, this is 78. Wow, wait, I thought we were back at our 74-year-old friend. You guys are awesome. I was impressed when my mother went to law school at 48. Of course, I was a little sport then. Anyway, no, you'll have to do some research about that, but I'm pretty sure that even this year somebody passed at 80, but that shouldn't stop you from passing right now. Get her done. Let's see. What support link to send in our February essays if we were a current student? Okay, so if you are in BarMax, well, you have to do it. Actually, this isn't helpful because I'm in the app, and you'll want to go to the website, probably the browser, although you might be able to do it here. When you go there, oh, I'm sorry, I didn't show you what I was doing. Get me out of here. So when I tap the upper left, I get the menu. And all the old office hours and webinars are there in under the clock. And right above that, the little headset is support. So when you tap the headset, you can reach out to support. And there we are. And that's not everybody. You'll get one of those people and one other person who are super busy right now. And the other ones are there on backup. But anyway, somebody will help you and they'll forward it on over to me and I'll direct the traffic on who should be looking at your essays. Okay, and that's Josiah. You're saying you were a current student when you took the bar in February. We are so sorry that you have to go through this again, but yeah, send it on over to us. We want to help you out. Okay, we're with you. Like, you know, I know our competitors like to sell the course multiple times to the same person, which is super cheesy. We're with you until you pass. Now, obviously, if you need a lot of time, we say get some tutoring too, but you have access to our materials and you have access to our support and can come to office hours and all of this, you know, until you're done passing the bar and moving on with your life and being an attorney and recommending BarMax, #1 ranked bar review course. If you look, we have lots of stars in the app stores right now. We appreciate your reviews after you pass. And anyway, I think I'm gonna wrap it up. And I think all of my students who wanted to connect have done so, and so I am done. I went a little longer than I intended, but you guys are great, and thank you for listening and participating. And again, the old webinars are all available for replay in this part. Oh, that's not the app. In the part of the app I just showed you with the clock. And if you want the old office hours, paid students also have access to the office hours that we've had in the past, and all the new ones will be posted too. So you can rewatch anything that you find helpful, and persevere. Happy studying. I want to see you succeed. All right. I'll see you in office hours. Bye-bye.